Hello and welcome to the Disability Law Show. John Scholes here. Beside me, James Fireman, going to be answering all your questions and emails and later on phone calls if you want to reach out to James and his team. Really simple, 1-855-821-5900. Help at disabilityrights.ca would be the email. A topic I love, James, a little later on in the show, and that is surveillance and long-term disability claims. We'll get to that in just a little bit here as we go through this 30 minutes. But the week that was, what's happening on your end, pal?
Well, John, as you know, I always like to talk about mediations that I have coming up. And there's one I have in the very near future that is, I think, particularly interesting. So my client in this particular case worked at a physical job, and she developed a back injury over time. And there wasn't really any dispute that she has a significant back injury. Her own doctors, her treating doctors have confirmed it. It's confirmed in medical imaging. It's objective. And the insurance company approved her benefits and then sent her for an assessment with one of their own doctors who confirmed that she has the disability, severe disability. In fact, their own doctor said that she cannot return to work, to her own job. So what does the insurer do? Well, they didn't cut off her benefits right away. What they did is they sent her for a work-hardening program. So a work-hardening program is something that's designed to, in theory, help people who haven't been working because of a disability get accustomed to the day-to-day process of going to work, get their bodies used to being up and about and the physicality of being in a work environment from, for 8 days or for 8 hours a day, 5 days a week. It was a 12-week program, but here's the thing. The stated objective of the program was to return her to her own occupation, her own physical occupation. The same occupation that both her treating doctors and the doctor hired by the insurance company has said very clearly that she was not able to do. One of the objectives of this work hardening program was also to reduce her pain. And because of that, her pain was actually measured at various points throughout this program. And what you actually find when you go through the file is that going through this 12-week unnecessary work hardening program that both the treating and the consulting doctors has said was not appropriate actually increased her pain. They forced her to go through a program that was completely medically unnecessary, that was not going to achieve any positive result, and in doing so, caused her significant increased pain. In fact, the medical notes show that after each session, she was in extreme pain for about 2 hours, and her overall pain during the 12 weeks went up considerably. Then they cut her off. So we have an insurance company that has denied benefits to someone who is clearly entitled, and there's all sorts of other reasons why their denial was not legitimate. But even putting all of those aside, the fact that they forced my client to submit to a work hardening program that was not only unnecessary, but that actually inflicted pain on her, puts the insurance company in a really, really bad position. They know very well that if they don't resolve our case at mediation, it means that there is a chance they're going to wind up in front of a judge. And if they wind up in front of a judge, they know very well, number one, my client's going to get the benefit she's entitled to, that's given. Number two, they're going to have to pay her for the pain and suffering that they inflicted on her. And number three, they're probably going to have to pay punitive damages. In other words, it's likely that a judge is going to look at the conduct of the insurance company and say that that was inappropriate, it was not fair, they did not fulfill their duty of good faith, and they have to pay punitive damages. And insurance companies don't like that because that is really bad publicity. Remember, if you go to court and there's a decision from a judge, that's public. That's something that the entire country has access to, and the media tends to pick up on those stories. So they want to avoid that at all costs, and it puts them in a very, very awkward position. They're really forced at mediation to pay whatever is necessary in order to get that done.
You know, it made her worse what they made her do with this work hardening program. I mean, at one point, I'm not saying she was wrong not to do it or to do it, but could she have said, guys, this is killing me, I'm not continuing? Or is it fear? It's a David and Goliath situation where she's afraid to say anything to the big bad insurance company.
Well, I think it's probably the latter. I think that's probably what her thinking was, that she couldn't really afford to do it. And it's a really difficult position for people to be in because at that point in time, her insurer was paying her benefit. And I can really understand why someone who is not physically able to work and doesn't have income coming in is going to do whatever they can to make sure that those benefits continue. And the reality is that if she had said, no, I can't do this, it's too painful, I can't do this anymore, the reality is the insurer probably would have cut off her benefits earlier than they did. So, in some sense, she didn't really have a choice if she wanted to keep getting paid. Now, having said that, what I'll say is that had she called me earlier, I certainly would have advised her that if she's at all able to weather the storm, in other words, to risk getting her benefits cut off earlier, then she should not continue doing something that is causing her extreme pain and is actually making her condition worse. And I'm sure her doctors would have agreed, and that's really who you have to go to make that decision. But I understand why she did what she did, because there's a financial reality that she was faced with and that a lot of people are faced with. And even if what they are being forced to do is something that is extremely painful and in fact harmful, a lot of people are going to make that same decision because they just can't afford to have their benefits cut off.
I want to take a moment to mention pocketemploymentlawyer.ca. We try to every show slip it in there. It's another source for you to ask questions to James or a member of his team. Even though it's a Pocket Employment Lawyer website, there's a rather robust section on disability law there as well. You can use that. It's another useful tool in your kit to reach out and get some more answers from James and his team. Again, pocketemploymentlawyer.ca. And we do get a ton of phone calls, as you know, James, on our radio show. Disabilityrights.ca is the website you're going to go to find a radio show close to you, where you can tune in weekly to all across the country, various markets. I want to get to our first phone call from the show and talk about that now, James.
My wife had a kidney transplant, so she had her medical time off. Her employer was great about it. Her medical insurer, after her 3 months, which was what they said was recommended for the heal time, had turned around and said, after the 3 months, you're cut off, you need to return to work, even though her doctor was saying that she needs more time off because of other complications.
So this is actually a pretty similar situation to what the client I was talking about just a moment ago was faced with, where an insurance company is essentially forcing you to do something that you're not medically ready to do. And so that's a decision that, each person is going to have to make. First and foremost, I have to make this perfectly clear. The decision to return to work or not return to work is not a legal decision. It's a medical decision. It's not something that you should be taking advice from your lawyer on or your insurance company. That is something that you should be going to your doctor. If your doctor is saying that you cannot return to work, that you should not return to work, then don't. If you can at all afford not to, if it is even in the realm of possibility, don't do it, because your long-term health is way too important. And so, that seems to be the situation with Jason's wife here, that, she's obviously had a very significant surgery and her doctors are telling her not to go back to work. So she shouldn't. And the reality is that one way or the other, the insurer is not going to continue to pay. If she goes back to work and she's able to do it, they're not going to pay her. And if she's not able to go back, or she decides not to go back to work and she defies what the insurer has decided, they'll cut her off then too. So either way, the insurer is likely to cut off her benefits, so she might as well do the thing that is most likely going to be in her best interest long term, and that is to follow her doctor's advice. The reality, what happens in a lot of these cases, John, is that we have insurance companies that are not really using common sense, and common sense is go to a doctor, get an opinion from somebody qualified. In a situation like this, where someone has had a kidney transplant, it really, I can't believe in that scenario that the insurer actually went to a qualified doctor about the recovery and that doctor said, oh no, she can go back to work even though there were complications. Almost certainly what happened is that the insurer got this claim and said, okay, we'll prove it, but we're only going to prove it within a certain time frame. And the time frame that they decide on is often not on the basis of the advice of a doctor. It's on the basis of MD guidelines. And that's this database that insurers often rely on that will have medical information, and it will provide benchmarks for how long you might expect someone with a particular disability to remain disabled for. But the problem is it's not contextualized. It doesn't take into account other issues that people might be dealing with, other disabilities they might have, nor does it take into account complications that Jason's wife is dealing with, for example. And so the result is you wind up with a decision that is based on very limited information without consultation with a qualified doctor that doesn't make any sense. And whenever I see that in a file, whenever I see that an insurance company has denied benefits on the basis of empty guidelines, and we do see that, if that's what they're relying on, that will be in the file, and they haven't also consulted with a doctor, you know the insurer's in trouble. You know that they're not going to be able to justify how they came to their decision, because that's not a fair process. It is not a fair process if you are not contextualizing the particular claim and you're not relying on a qualified expert to provide you with advice.
Let's take a short break. Lots more to come. As mentioned at the top of the show, surveillance and long-term disability claims. Let's get into that when we come back. 1-855-821-5900 and disabilityrights.ca as well. Stick around. Coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Thanks for sticking around. John Scholes, James Fireman, Disability Law Show, reaching out anytime for you. We throw it up on the screen throughout this 30 minutes. 1-855-821-5900. Help at disabilityrights.ca. James, I know we talk about this topic quite often on our long-running radio show, and that is the concept and the topic of surveillance and long-term disability claims. I love this one. Why do insurance companies go to surveillance? Why do they use it?
Well, it's a really good question, John, because you have to think about insurance companies and what their incentives are. As I talk about whenever the topic of appeals comes up, it's relevant to understand insurance companies are corporations with shareholders. They're in business to create profits for those shareholders. That is what they are there to do. And so they don't like to spend money unless it is something that is ultimately going to make them more money down the road. And so when an insurance company goes out and hires an investigator to conduct surveillance, that costs them money. Those investigators aren't on their payroll. They go out and they hire a private firm to follow their insureds around. And that costs them money, often $5,000, $10,000. So why are they doing that? Well, the only reason they're going to do that is if they believe it's going to save them money down the road. In other words, if they think that they are likely to find something within that surveillance that will provide them with the justification for denying or cutting off a claim. That's the reason why they do it. But a lot of times they do it in situations that, to me, frankly, don't make a lot of sense. You know, if you're dealing with somebody who, for example, has a cognitive issue, does it make a lot of sense to go out and get surveillance? Are you likely to find something in there that is going to show that the person isn't disabled? And here's the other thing. If an insurer goes out and spends $5,000, $10,000 on surveillance, and doesn't get anything that's definitive in the surveillance that suggests that the person is not disabled, well, what do you think is going to happen in that scenario? Do you think the insurance company is just going to say, oh, well, too bad, I guess we spent the money and it's gone now? No, they're going to look through it with a fine-tooth comb, and they're going to cherry pick the things that will help them. If there is even anything that comes close to justifying cutting off the claim, that's what they're going to do, because they've spent the money and they have to justify to their managers and to their supervisors why they spent this money if they're not going to be able to cut off the claim. That's what they're trying to do. So there is an incentive as soon as they spend that money on this surveillance to use it as a basis for cutting off the claim. And they do that oftentimes even when there isn't sufficient evidence within that surveillance to justify terminating benefits.
Well, I mean, when it comes to surveillance, nobody likes being watched, right? Should anybody be doing something different knowing that the insurance company's got surveillance on them?
Well, so that, first of all, you have to think about, what type of claim that you have. And by what type of claim, I mean, do you have a legitimate disability? So if you are someone who is legitimately disabled, then you really shouldn't have to worry about how you're conducting yourself. If you are acting reasonably and you have a legitimate disability, it doesn't matter if the insurance company hires an investigator to conduct surveillance every day. They're not going to find anything that it will justify cutting off your benefits. If you're acting reasonably and you're legitimately disabled, there's nothing to hide. But if you feel like you are being followed, don't assume that it's an investigator from the insurance company. That might, in fact, be correct. You might be correct. It could be someone hired to conduct surveillance on you by the insurer. But you don't know that. It's not like they walk around with the sign that says, hired by Acme Insurance Company to conduct surveillance on you, right? Like, you don't know who they are. And if you have someone following you around, call the police. Don't take your safety into your own hands. Call the police. If you notice someone following you around, use common sense. Unless you are 100% sure who they are, and I'm not sure how you could be certain, then call the police, make sure that there is a report filed. And if you see them again, call the police again and ask them to do something so that that person is going to stop following you around.
So they spent all this money on surveillance. Will they cut you off your LTD claim based on that surveillance?
Well, sure they can, and in certain situations, they'll be well justified. If you're talking about someone who is trying to bring a fraudulent claim, and they're not, they're obviously not legitimately disabled, and let's say they're actually working while they're saying that they're disabled and can't get out of bed, and the insurance company hires an investigator, and they have surveillance of you going to and from an office every day, and they conduct searches on your social media and realize that you're working. Well, yeah, they can absolutely cut you off in those circumstances, and they should. I'll be the first person to say it. They absolutely should in those circumstances. If you're trying to game the system, they should do what they can to stop you. I have no issue with that. But it's in fact very rarely the case that you're going to find anything nearly as clear as that. Usually it's going to be much more subtle. It's just going to be people going about their day-to-day business. And you can't really tell in a lot of situations if someone, especially someone that isn't suffering from a physical disability, but someone suffering from emotional, psychological, or cognitive issues, how are you going to be able to tell based on what they're doing in their day-to-day activities whether or not they're disabled? If you see them going to the Tim Hortons drive-through 2 or 3 times, or you see them, going out shopping at the grocery store, what does that really mean? Does that tell you anything about someone's ability to be able to handle the day-to-day work environment, the pressures of working full-time job? No, it really doesn't. Does that tell you anything about someone who's having cognitive issues with their memory, or someone who has difficulty concentrating? Does that really tell you anything? No, it really doesn't. So, more often than not, even if the insurance company is going to try to use that surveillance to justify cutting off your benefits, it's usually not going to be a valid use of that surveillance. And often what we find is that the surveillance winds up being the strongest evidence in support of the disability. And here's what I mean by that, John. They hire someone to conduct surveillance of you for 5 or 6 days in a row. And all they find during those 5 or 6 days is that you are doing very trivial things. Some days you're not even leaving the house. Other days when you go, you do, the drive-through, get your coffee, your double-double, what have you. That is pretty good evidence that you are not capable of doing anything. If you, when you're not aware that you're being watched, are not doing anything, well, that should give the insurer a pretty good clue that you're disabled. Now, what I will say is, over the last year or so, pretty much nobody's doing anything these days. So I don't know whether it really is going to help either the insurer or my client. But in normal circumstances, when people aren't under lockdown or aren't worried about a pandemic, and you find that they are housebound for 5 or 6 days in a row, that's pretty strong evidence.
So if someone has been cut off because of the surveillance, what's the first steps? What should they be doing?
Give us a call, man. You give us a call. 100% free consultation, no matter what your circumstances are. If you have any questions or concerns about the long-term disability process, whether you are worried about surveillance, you think someone's been following you, or whether you're about to apply, or whether you are on claim already and you're concerned with something your insurer is doing, give us a call. It's a 100% free consultation. No one's going to ask for your credit card. So you're not going to be charged for anything. If you do wind up hiring us, you're still not going to pay anything out of pocket. We work on a contingency. So you're never going to have to pay anything out of pocket. And you certainly don't have to worry about paying anything for a consultation.
And by the way, once you are hired by a client, you have access to all of that surveillance, right? Cough it up.
Oh, yeah, absolutely. So oftentimes insurers don't like to provide that to their insureds, but as soon as we bring a legal claim, they have to. They don't have the choice. So they have to provide all of that surveillance evidence, all of the reports from their investigators, all of the video, all of the photographs, and we can see everything. And more important, we can see how long the surveillance was conducted. Because oftentimes when they get the surveillance, they're going to cherry pick one or two things, a couple of moments in time, and take them out of context and suggest that it shows that you're not disabled. But when the reality is that they've actually been following you around for 80, 90 hours. And in those 80 or 90 hours, if that's all you're doing, it paints it in a very different light. So it's important that you see the entire surveillance file.
Okay, one more quick break. Lots more to go here. In the meantime, 1-855-821-5900. help@disabilityrights.ca through email or simply disabilityrights.ca. You want to find a radio station that carries our show close to you? Just go there. We'll continue. Disability Law Show. Stick around.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, thanks for sticking around. I want to mention another resource. I think I did it at the start of the show, but mydisabilityquestions.com, a free website open to you to ask your questions. A member of James' team will get to those questions. You can also search the database of previously asked questions. Maybe yours is there, one similar to it, and have all the answers. I want to get to Nicole. Nicole, thank you for using it. Says, I've been a private teacher for more than 20 years. I had a really bad concussion earlier last year when I slipped on some ice and now suffer from headaches and noise sensitivity. I could barely look after my 5-year-old son. I applied for LTD benefits but was denied. When I appealed, they claim that the surveillance showed I was able to function normally. Are they correct? There you go.
Well, Nicole, I appreciate you writing us. Now, obviously, I can't say for sure unless I've actually seen the surveillance. But
Sure.
we can try and piece together what's happened here. So, first of all, and I mentioned this before when we were in the last segment talking about surveillance. When you hire an investigator to follow someone around who has mental health issues or cognitive issues, which you're likely to have as a result of a concussion, and that seems to be what Nicole is talking about here, what are you likely to find here? So she says that she's suffering from headaches and noise sensitivity. Well, unless you have video surveillance of her intentionally going to places that are very noisy and crowded, and staying there for an extended period of time, are you going to be able to show anything in the surveillance that will determine that issue one way or the other? Or are you going to be able to tell whether or not she's got a headache? And if it's a severe headache, I suppose you would see her lying down. But just because someone is out and about walking around or driving somewhere or going shopping, that doesn't mean that they're not also suffering from a headache. In fact, it could be a really bad headache. Some people just suck it up and go about their duties because they have to, because they have 5-year-old children that need to be cared for. And so you go on with it. That's what parents do. So just because you have surveillance video of someone going about what looks to be normal day-to-day activities does not mean that they are not suffering from a disability, and it certainly doesn't mean that they're able to go back to their pre-disability occupation. In this particular case, Nicole has told us she's got difficulty caring for her 5-year-old son. So that should give us some insight in the extent of her disability. If she is truly having issues caring for her 5-year-old son, how is she going to be able to handle a class of 20, in fact, probably 30 or 35 kids? How is that going to work? How is that going to even be possible? So it seems pretty unlikely that the surveillance is going to be something that should legitimately be relied on by the insurance company. But of course, again, I have to throw in the caveat, unless I look at the surveillance directly, I can't really say for sure one way or the other.
I want to get to a quick email in the last couple minutes here from Anthony. James, again, help@disabilityrights.ca, says, I've been on LTD for the last 3 years because of depression. A few months ago, I made something of a breakthrough in my treatment and feeling much better. I'd like to go back to work, but I'm not sure whether I should try. If I decide to return, how do I go about making this happen? And what happens if things don't work out and I regress?
I really love this question. And Anthony, thank you so much for writing to us. And I want to make sure that anybody out there who's watching hears this very clearly. If you are on disability and you get better and you're able to go back to work, whether or not you've been cut off and you started a legal claim or you're still getting your benefits, you should do that. If your doctors approve, if your doctors say you're medically fit to go back to work, you absolutely should. If you're able to earn 100% of your income, that is so much better for you than trying to recover 2/3, which you typically would get in a normal LTD policy, and maybe not get all of that if they cut you off and you have to bring a legal claim and you have to pay legal fees. You can go back to work, you should. So if you are in Anthony's situation and you're getting benefits and you feel like maybe you can go back to work, here's what you do. Number one, talk to your doctor. Make sure that your doctor agrees that you're medically fit to go back to work. And if they do, make sure you canvass whether there are any restrictions or limitations. Should you start off gradually, a limited number of days, limited hours per week, slowly increasing over 6 to 8 weeks is usually the way that it goes. Are there any duties or responsibilities that you should avoid doing to make sure you're not aggravating your disability? Whatever the doctor says are your limitations or restrictions, get a letter from your doctor. Then you approach your employer and you ask your employer if they can accommodate the gradual return to work schedule and the limitations and restrictions. Once you have your doctor and the employer on side, then approach your insurer and say, okay, I think I'm ready to go back to work. You don't want to say you're sure. You want to say you think you're ready to go back to work. Your doctor has said it's okay for you to try, and your employer has said that they can accommodate. If you do that in that process, you put yourself in the best possible situation. And if you do attempt to go back to work and you're not able to do it, you try, but your disability gets in the way or you regress in some way, almost all insurance policies are going to have a recurrence clause, which is really useful. It means that if you try to go back to work and you're not successful, that you are able to continue receiving your benefits without having to wait the 4 or 6 month elimination period that you typically have to go through. And so it's a great little insurance policy, so to speak, within your policy that allows you to try and go back to work without having to worry about what happens if you're not successful.
Recurrence clause, remember that. Recurrence clause is what it's called. Look at your policy for more information anytime, of course. James, good stuff today. You want to reach out now that we are done for the day, 1-855-821-5900, help@disabilityrights.ca, and the website, disabilityrights.ca as well. We'll catch you next time right here on the Disability Law Show. Thanks for watching.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.